the other members of this committee. Thank you for the opportunity to be here. I'm so encouraged to be able to talk to you about my advocacy with forced arbitration and the work that I've done to make Americans so much safer in the workplace. In 2016, I somehow found the courage to come forward against then Chairman and CEO of Fox News, Roger Ailes, for sexual harassment. It was the toughest decision of my life. But after my career that I had killed myself for was taken away from me, I thought to myself, if I don't do this, who will? My story made headlines around the world, but it could have easily been swept under the carpet because of a forced arbitration clause in my own employment contract. No one starts a new job expecting something bad to happen to them. I know I didn't. And in the face of a new opportunity, few people can walk away from a job opportunity because of the fine print. I don't care who you are. You don't understand what forced arbitration means.
The U.S. Senate Special Committee on Aging will now come to order. We are proud of the bipartisan history of the Special Committee on Aging, and to maintain that tradition in this Congress, today's hearing will be led by Ranking Member Gillibrand. Turn over to the Ranking Member.
Chairman Scott, thank you so much for providing me with the opportunity to discuss this incredibly important topic, age discrimination. And thank you to our witnesses for being here today, for fighting for the rights of older Americans and their families. You all know what it can be like to spend a lifetime working hard, building your career, and contributing to our economy. And you can imagine how devastating it can be to experience discrimination because of how old you are. Nobody wants to feel like their contributions don't matter, especially not because of some arbitrary characteristic like age. But far too often, older workers are being denied employment, passed over for promotions, or even fired because of their age. According to research conducted by AARP, 64% of workers aged 50 plus have seen or experienced some form of age discrimination in the workplace. And of that population, 90% believe that age discrimination against older workers is commonplace in the workplace. In that same report, more than 1 in 5 older Americans said that they worried that they are being pushed out of their job because of their age. This comes as Americans have started working later in life, with workers who are over 75 years old becoming the fastest growing age group in the workforce. Just ask the U.S. Senate. In a time when the population of older Americans is growing and many are returning to the workforce, we need to make sure that those who face age discrimination can have their day in court. Victims of age discrimination often can't seek justice or accountability in court because of forced arbitration clause that they signed when they were hired. Many employees are not even aware that their employment contract contained a forced arbitration clause. It traps those who experience workplace discrimination in a system that advantages their employer, preventing them from seeking information that could prove their case. And victims are left at the hands of an extrajudicial arbitrator who is often selected by the employer and not always a trained lawyer. It's no surprise that employees are often less likely to win in arbitration than they are in court. Building on our successful effort to ban forced arbitration in cases of sexual harassment and sexual assault, Senator Lindsey Graham and I introduced the Protecting Older Americans Act, which would invalidate forced arbitration clauses in cases of age discrimination as well. It would also allow those who have experienced age discrimination the option to file their case in court if they choose, even if they previously signed a forced arbitration clause. It gives them a voice in a process and the ability to seek justice. If employees decide, though, that they would like to pursue arbitration when they have faced age discrimination, they can. The point is that employees will now have this fundamental choice. The crux of the issue is that despite the fact that the workplace age discrimination is categorically illegal and that Congress has already passed laws to protect older Americans from it, forced arbitration clauses subvert justice. They take away your constitutional right to a jury without you knowing about it. They allow employers to hide illegal conduct behind closed doors. And they shield those who have committed serious misconduct from the public eye. But now we have an opportunity for broad bipartisanship at a time when many Americans feel Congress is too divided to get things done. I look forward to hearing from our witnesses today, as well as discussing these critical issues. Thank you, Mr. Chairman.
Thank you, Ranking Member. First off, thanks everybody for being here. We've gathered to discuss a very important topic, not just for our aging community, but also for generations planning for retirement, and for those who won't be retiring for several decades. Today's hearing will focus on the value of our older Americans in the workplace, what we can do as elected officials to help protect and foster a purpose-filled life for our aging constituents. I look forward to a discussion today on how we fight against age discrimination by highlighting the positive impact of older Americans' engagement in their communities, and how aging Americans who remain engaged create benefits for themselves and our economy. I want to be clear about something. Age discrimination is clearly wrong. It's stupid. I built businesses. I can tell you that looking at someone's age instead of the value they bring to an organization absolutely makes zero sense. You can't run a business or government that way, and we need to make sure it's not happening to any American senior. Work provides purpose, fulfillment. These are powerful forces that enrich families, strengthen communities, and support the health and longevity of our nation and its people. Having a purpose is an essential part of the American dream and has long been an indicator of both mental and physical well-being across all age groups. Research shows that older adults who remain engaged experience greater physical health, mental resilience, and life satisfaction. Employing older Americans is good for business too, because these folks have years of wisdom, the ability to mentor the next generation of leaders, and a valuable perspective on issues leaders in business and government face each and every day. To be clear, not every older American wants to stay in the workforce. Finding purpose will be different for each person. For some, it will be taking a class or a course to explore an area of interest, volunteering in the community, or dedicating time to pursue a new hobby. But for many seniors, purpose will be found in continuing to work in some capacity. This could be in their previous business as a new part-time employee, at a place they enjoy frequently, or even branching out and starting something new. We need to make sure Americans of all ages have the opportunity to work and pursue their dreams by stopping age discrimination and removing the red tape and barriers that hamper or discourage older Americans from continuing to work or starting a new business or career. We did this in Florida when I was governor. We cut taxes. By cutting taxes and costly and unnecessary regulations, we managed to turn the economy around, making it a beacon for businesses and those wanting a full and purposeful life. During my years as governor, we cut taxes more than 100 times and slashed more than 5,000 burdensome regulations. We cut the time it took to get your license or permit from the state of Florida from weeks to days. Florida businesses added 1.7 million jobs. We paid down over $10 billion of debt. We increased the efficiency of government to provide additional services for our citizens and our state, including for our seniors. And as a result, many seniors moved to Florida because there's clearly better business opportunities there. Because of these policies, Florida is well known as the place that thousands of retirees flock to each and every year, escaping less financially hospitable climates. Some to retire, some to start businesses. In Florida, their dollars go farther, and they have communities and opportunities to experience connection and fulfillment without the fear of age discrimination. I want to thank my colleague, Ranking Member Gillibrand, for our focus on this important topic, and look forward to a productive and meaningful conversation. So I think you're going to go.
Thank you, Chairman Scott. I want to introduce our first witness, Nancy Lehman. Ms. Lehman serves as the Chief Advocacy and Engagement Officer for AARP, and she has the responsibility of driving the organization's social mission on behalf of the Americans 50 plus and their families. In this capacity, she leads AARP's legislative campaigns, manages public education, volunteerism, multicultural outreach, and engagement. Thank you, Ms. Lehman. You may begin.
Thank you. Chairman Scott, Ranking Member Gillibrand, members of the committee, thank you for the opportunity to testify today. As you said, my name is Nancy Lamond, and I serve as AARP's Executive Vice President and Chief Advocacy and Engagement Officer. On behalf of the 100 million Americans aged 50 and over, I also want to thank you for working in a bipartisan way to highlight so many issues important to older adults. Hearings like this, as well as others, including Senator Scott's recent field hearing on fighting fraud, help move us towards solutions that will allow Americans to age with dignity. Today's topic of age discrimination is critically important. It is an under-discussed and under-recognized issue that has real implications for the growing population of older Americans who are working longer than ever before, many because they need to make ends meet. According to the Federal Reserve's Survey of Consumer Finances, 54% of households have no retirement savings. Among those who do, the median savings for folks 55 to 64 is $185,000. And it's worth noting that the number for older women, particularly those who are divorced, widowed, or never married, is significantly lower. As we all know, this number is well below what's needed for a secure retirement, even factoring in Social Security, and likely one reason that folks 75 and older are the fastest growing segment of the workforce. At the same time, nearly 2/3 of workers age 50 plus tell us they've seen or experienced age discrimination, and 40% of job seekers over 45 say they've faced it looking for work. Research shows that half of workers in their early 50s experience involuntary job loss, and older Americans are more likely than their younger peers to be unemployed for 6 months or longer. More than half of older job seekers report being asked to provide age-related information during the application process, and the algorithms used to scan resumes and applications can accelerate bias, using graduation dates or years of experience as proxies for age to screen out otherwise qualified candidates. Talk to older job seekers, and they'll tell you they hear things in interviews like, "You're overqualified," "We're looking for a digital native," or "a more energetic candidate." This is undermining the financial stability of too many capable Americans. It's also economically damaging to our country. AARP research shows that age discrimination costs the U.S. economy $850 billion every year. Simply put, sidelining experienced workers is also a loss we cannot afford, and Congress has the power to help fix this problem. I want to commend Senator Gillibrand, who along with Senator Graham has introduced the Protecting Older Americans Act and mandatory arbitration in age discrimination claims, a practice that silences workers and denies them the full protection of law. AARP is proud to support this common sense law. Other bipartisan bills that we think should be considered by the Congress include the Protecting Older Workers Against Discrimination Act and the Protect Older Job Applicants Act. AARP is also working at the state level, promoting policies to ban age-related inquiries in the initial hiring process and to secure funding to help retrain older workers. We're partnering with employers to build more age-inclusive workplaces through initiatives like our Employer Pledge Program, which has over 2,000 businesses. And we help older Americans sharpen their skills to stay competitive. It's going to take an all-of-the-above approach to really make progress. Again, thank you so much for holding this important hearing and for the opportunity to testify on behalf of older Americans who ask only for fairness and respect in the workplace.
Thank you very much, Ms. Lamont. I want to now introduce our next witness, David Horton. Professor Horton is the Fair Business Practices and Investor Advocacy Professor of Law at the University of California, Davis School of Law. Professor Horton's teaching and published works are focused on wills and trusts, arbitration law, and contracts. You may begin.
Thank you, Chairman Scott, Ranking Member Gillibrand, and distinguished members of the committee for the opportunity to speak today. My name is David Horton. I teach at UC Davis, and one of my areas of specialty is forced arbitration. So we just heard from Nancy about how age discrimination harms older workers, and I'm going to talk about how forced arbitration compounds those harms. At the outset, I should say that I believe that arbitration can be socially valuable. For example, it would allow two businesses in a particular industry to submit a dispute to a specialist in their field rather than a generalist judge. But for two reasons, I oppose the forced arbitration of claims that are as pernicious and as pervasive as age discrimination. First, although arbitration derives its legitimacy from the party's consent to bypass the court system, forced employment arbitration is not consensual. Think of some of the ways that employers force employees to arbitrate. Sometimes they put arbitration provisions in onboarding paperwork, but studies confirm what our common sense tells us. At that time, workers are bombarded with information, they don't read or understand the fine print, and they have no idea that they've waived their Seventh Amendment right to a jury trial. Moreover, even if workers did read and understand forced arbitration provisions, they would have little choice. Who has the luxury to say no to a job because they don't like the fine print? And it would make no sense to leave a position for another position, hoping that it wouldn't be subject to arbitration, because statistics show that forced arbitration is so pervasive that the odds are any other job would also be subject to the process. Employers often also impose arbitration on people who have been on their payroll for years and even decades. So consider an example from a recent age discrimination case. There was a woman named Joanne Grace. She started as a nurse in 1976. It wasn't until 2019 that she took an online training that culminated with her clicking a button saying she agreed to arbitrate any dispute with her employer. A year later, a new supervisor was assigned to her who made derogatory comments about her age and ended up firing her and replacing her with a younger worker. So she sued for age discrimination, but a federal court in Ohio compelled arbitration of her claim. It's not true that her consent to arbitration in that context is meaningful. Was she really going to leave a job that she loved, that she'd been working at for 50 years over something like forced arbitration? The second reason that employees should not be compelled to arbitrate age discrimination claims is that there are systemic differences between litigation and arbitration that make it harder for plaintiffs to vindicate their rights. For example, employment discrimination often arises out of company-wide policies, which calls out for class or collective proceedings, but you can't bring class or collective proceedings in arbitration. Forced employment arbitration also has a repeat player problem. So unlike judges, arbitrators are selected by the parties and paid by the hour. So they have an economic incentive to rule in favor of the only party who's going to be in a position to select or veto them again in a future case. And this concern about arbitral bias is especially pressing given the rising phenomenon of employers paradoxically assigning arbitrators the task of determining whether or not the arbitral process is fair. So for years, courts applied the contract doctrine of unconscionability to invalidate arbitration clauses that tried to tilt the scales of justice. But in a 2010 decision called Rent-A-Center West versus Jackson, the US Supreme Court gave its blessing to delegation clauses, which allow arbitrators to decide that issue. If an arbitrator holds that the arbitral process is rigged, they're taking money out of their own wallets by denying themselves the power to hear the merits of the case. So there is growing empirical evidence that arbitration's differences, its lack of class and collective proceedings, its risk of biased decision makers, its limited discovery, are deterring plaintiffs from pursuing claims. Scholars estimate, based on filing levels in federal and state court and the percentage of employees who are subject to arbitration clauses, that you would expect to see between 323,000 and 727,000 employment arbitrations every year. How many arbitrations are actually filed by employees? In the leading arbitration providers, the AAA and JAMS, the number is 2,000 to 3,000. So what we know about the prevalence of age discrimination, many of these missing abandoned claims have to be seeking redress under the ADEA or its state analogs. For these reasons, although we describe arbitration as alternative dispute resolution, forced employment arbitration is not alternative dispute resolution. It's not an alternative because employees have no choice. It's also not an alternative to anything because it's increasingly the norm. And it's not dispute resolution because its purpose isn't to resolve disputes, it's to suppress them. One step in the right direction would be for Congress to pass the Protecting Older Americans Act. This bill gives workers with age discrimination claims, what they've been sorely lacking for decades, the freedom to choose a forum in which to seek justice. Thank you again for the opportunity to testify.
Thank you so much, Professor Horton. Appreciate it. I want to move now to our next witness, Gretchen Carlson. Ms. Carlson is a former Fox News journalist and co-founder of a not-for-profit, Lift Our Voices, which works to end the silencing of harassment victims through forced arbitration and non-disclosure agreements. A champion for workplace equality, Ms. Carlson was named the Time magazine's 100 most influential people in the world after her bold actions against Fox News, which not only helped to pave the way for the global Me Too movement, but was the leading advocate to change the law to eliminate forced arbitration in the workplace for sexual assault and sexual harassment. You may begin.
I should know how to do that by now. Thank you so much. Chairman Scott, I think I have not seen you since we were on Fox and Friends together years ago at the Villages, and we were wrestling a baby alligator together. So it's great. It's great to see you again.
Both survived.
And We both survived. We did. It was tiny. Ranking Member Gillibrand, thank you so much for your support on these issues, and to the other members of this committee, thank you for the opportunity to be here. I'm so encouraged to be able to talk to you about my advocacy with forced arbitration and the work that I've done to make Americans so much safer in the workplace. In 2016, I somehow found the courage to come forward against then Chairman and CEO of Fox News, Roger Ailes, for sexual harassment. It was the toughest decision of my life. But after my career that I had killed myself for was taken away from me, I thought to myself, if I don't do this, who will? My story made headlines around the world, but it could have easily been swept under the carpet because of a forced arbitration clause in my own employment contract. No one starts a new job expecting something bad to happen to them. I know I didn't. And in the face of a new opportunity, few people can walk away from a job opportunity because of the fine print. I don't care who you are. You don't understand what forced arbitration means. In my case, it showed up in my last contract with Fox. And while I asked a lot of questions, I was told not to worry about it because, quote, it was becoming the way of the world. Eerily, I had no idea at the time how true that was. Today, more than 60 million American workers are subject to forced arbitration. Most have no idea that signing on the dotted line means they've accepted forced arbitration as their only remedy for justice. So after my story, I started walking the halls of Congress, and in 2022, thanks to members of this committee and other champions in Congress from both sides of the aisle, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act was signed into law, one of the proudest moments of my life. That meant that Kristen Tiger, a bartender at a prestigious country club facing harassment, she was able to bring a lawsuit since that law passed against her employer last year. And even though her employer still tried to compel the forced arbitration clause, the request was denied because of that law. A federal judge in Texas also declined to grant Blaze Media's motion to dismiss after one of its employees, Sydney Watson, she also claimed harassment. Watson's case can now also continue in the court of law, thanks to the new law. But there's still much more work to do. Last year, in one of the most outrageous stories that you probably heard of, a wife and mom died of an allergic reaction at a Disney restaurant after staff confirmed to her that the food was safe. Disney tried to force her husband into arbitration because, get this, he had previously signed a Disney Plus streaming subscription confirmation email, which included a forced arbitration clause. Only after enormous public outcry did Disney waive the arbitration clause and allow the case to proceed in court. How about our kids? Parents of a 14-year-old girl in California claim she was coerced into sharing graphic images online with two companies. Both companies tried to force the family into arbitration, into secrecy, meaning other families of this alleged predator with at least 20 other child victims would never be able to know about him. Pertinent to why we're here today, Sam Cassell was promoted 7 times as a top sales rep throughout his 24-year career. Despite a better sales record than his younger peers, he was forced out and terminated. And due to a forced arbitration clause, he had no ability to seek justice in the court system. These personal stories are why I'm a champion as well of the Protecting Older Americans Act, reintroduced today by Ranking Member Gillibrand and Senator Graham, also co-sponsored by the chair and ranking member of the Senate Judiciary Committee, Senators Grassley and Durbin. Too many people are still not getting the simple freedom of choice when something bad happens to them at work. Now, just for a minute about the naysayers out there, we haven't seen what the chamber claimed was going to happen after we passed the EFAA, that all hell would break loose, and if you let women file their assault and harassment cases in court, there would be a slew of new cases everywhere, and companies would go out of business, but none of that has happened. Instead, we're just cleaning up the workplace and getting rid of a few bad apples. I believe the same thing could happen with this bill. A close friend said to me after my lawsuit at Fox News, something good is going to happen from this, Gretchen. And I didn't really see it at the time, but something great has happened from this. I thank you for holding this hearing. I hope you'll agree this is a bill we can all get behind regardless of politics. Maybe we can all start by agreeing that all of us here today are part of the age category. Let's take this on together, and I thank you for your time.
First off, thanks. Thanks all of you for your testimony. I'd now like to introduce Rachel Gressler. Rachel is a nationally recognized expert on workforce, retirement, and fiscal policy. As a senior research fellow at the Heritage Foundation, she has spent over a decade analyzing and advising on issues such as fiscal policy, pensions, and labor policy. Before joining Heritage in 2013, she served as a senior economist for the Joint Economic Committee of Congress for 7 years. Her research is marked by a commitment to promoting economic growth, individual freedom, and fiscal responsibility. Her expertise and passion for practical, people-focused solutions make her an invaluable resource for today's discussion on the role of purpose, responsibility, and engagement in later life. Thank you. Please begin your testimony.
Chairman Scott, Ranking Member Gillibrand, and members of the committee, good morning, and thank you for the opportunity to be here today. In my remarks, I would like to cover 3 points. First is that older Americans are an increasingly vital contributors to our economy and the fabric of society. Second, their continued engagement and productive activities provides huge benefits across generations. And third, policymakers can and should remove barriers that make it harder for older Americans to stay engaged in ways that are meaningful to them and beneficial to society. Today, about 1 in 4 Americans are ages 55 and older, and this share is steadily rising due to longer life expectancies, a declining fertility rate, and the aging of the baby boomers. Moreover, almost a quarter of the labor force is 55 and older, and that has also been arising alongside improvements in health and also more flexible work opportunities. And this continued work is not just about necessity, but because people find purpose and meaning in it. While retirement is often considered a one-time event, we're seeing more older Americans choose a transitional retirement, often giving up their full-time job and pursuing part-time employment or independent contracting that provides more flexibility. A recent survey found that 26% of baby boomer professionals and 38% of silent generation professionals engaged in independent work. And beyond paid employment, older Americans make enormous contributions in caregiving and volunteering. For example, 20% of grandparents care for their grandchildren at least once a week. And older Americans have the highest volunteer rates in America: community mentors, church volunteers, and hospice companions. These activities foster strong families and strong communities. And moreover, continued engagement, whether paid or unpaid, improves older Americans' happiness, their financial well-being, and also their health. That includes reducing the risk of chronic disease, cognitive decline, and depression. I've seen the benefits of aging with purpose firsthand. My grandfather, after retiring from a long career in the Marines, started a small accounting business in his home. My father spent decades practicing medicine and then partly retired and spent another decade doing independent medical exams. My mother left her full-time job, but still serves as a law guardian for children and also offers her legal services pro bono. And it was because my grandmother cared for me and my older sister that my mother was able to attend law school. Despite all the benefits of older Americans staying engaged, certain public policies impose obstacles instead of opportunities. One example is Social Security's retirement earnings test. This Great Depression era policy was meant to push older Americans out of the workforce to free up jobs for younger workers. Today, we need more workers, not fewer. This outdated test functions like an additional 50% tax on the Social Security benefits of workers who are under age 67. That leads to marginal tax rates as high as 84% on middle-income older workers. Not surprisingly, this prevents many of them from working as much as they otherwise would. I estimate that eliminating the earnings test could bring up to 1 million older Americans into the workforce. That would reduce poverty, increase incomes and output, improve health outcomes, and boost federal revenues, all by simply allowing Americans to work as much as they would like without a penalty. Other barriers come through regulations that restrict work opportunities and that make it harder to start a business. For example, the Biden administration's rule on independent contractors limits flexible job options. In California, a similar rule was found to reduce self-employment by 10.5%. Two bills, the 21st Century Worker Act and the Modern Worker Empowerment Act, would free up flexible job opportunities and enable more Americans to be their own bosses. And for older Americans who want to start a business, franchise ownership offers a proven business model with less risk and often lower startup costs. But a Biden administration rule could upend that model. The Save Local Business Act would make it easier for Americans to start and grow small businesses. And a package of proposals recently introduced in the Help Committee would help make it easier for independent workers to access traditional workplace benefits like retirement savings plans and health insurance. In conclusion, everyone benefits when older Americans have equal and ample opportunities to stay engaged in work and in society. By removing barriers to work, policymakers can free up opportunities for older Americans to contribute to stronger families, stronger communities, and a stronger economy. Thank you.
Okay. Thank you all for your testimony. Ms. Carlson, you noted in your testimony the Protecting Older Americans Act has bipartisan support. The bipartisan support of this bill reflects the coalition that you have been working on and building to give workers a choice in how they address their discrimination claims. Your organization, Lift Our Voices, includes both Democrats and Republicans as supporters of its goal. What are some of the reasons your allies in the movement, whether Democrat or Republican or independent, have given their support to oppose forced arbitration? And anecdotally, what have you seen in terms of momentum for why we should pass this bill now?
Thank you so much, Senator. I think it's a variety of different things. I always describe this movement as a perfect storm. When I came forward, luckily because my lawyers found a way to make my case public, even with my forced arbitration clause, or we wouldn't even be having this discussion. That happened, and then a tidal wave of other women came forward. But really what was also essential was that the media started covering these stories. And I can say this as a member of media, that had it been pitched before 2016 as an idea, it probably would not have been covered. So the media became interested in covering these stories. Social media actually helped because it allowed people to come forward either anonymously or with their face on their story in droves. And suddenly it became a worldwide issue. But the third thing that really helped this perfect storm happen, where people became more educated on these issues, is that the American public got mad because they thought we had come a lot further along in this process of protecting people at work, whether it's age discrimination, sexual harassment, or any other kind of discrimination. Why did they think that? Because they didn't hear about these stories. And why were they not hearing about these stories? Because they were all going to the secrecy of forced arbitration. There's been an explosion of the use of forced arbitration. 1991, 2% of all employees were under it. This year, more than 80% will be under it. It's been an explosion. So the American public got mad, and they were like, wait a minute. I thought we were more equal and fair to all of our workers across this country. And so I think that the education behind this has been crucial, where more people are starting to understand what forced arbitration is. And actually, when they find out what it is, they don't like it. Last year, Lift Our Voices commissioned a study with the Morning Consult. And more than 70% of all Americans, when they understand what forced arbitration is, and it takes away their choice and their Seventh Amendment right, they're against it. And what the study actually found was that the percentages are higher in southern states and higher amongst the most conservative of those surveyed when they understand what it is.
Right, because you're taking away someone's constitutional right to a jury trial, a jury of their peers to judge an issue and not be shuttered behind closed doors. And as you know well, Gretchen, a lot of these forced arbitration clauses are paired with non-disclosure agreements. And so you're forced into silence regardless. Ms. Lamond, in your testimony, you cite an AARP report that found age discrimination draining $850 billion from the U.S. economy every year. This is a shockingly high number. You also cited an Urban Institute study that found 50% of workers in their early 50s experiencing involuntary job loss. Can you please go into more detail on the emotional and economic impacts that age discrimination has on the older workforce? And what is the workforce losing due to age discrimination?
Well, Senator, both you and the chairman spoke a little bit about it in your opening remarks. This is devastating for individuals and also can be overall for the workforce if we lose this valuable resource that I think everybody on the panel has spoken about. And when you talk about individuals and their families, it has tremendous impact. Rachel mentioned volunteers, and no organization is prouder of their volunteers than AARP, many of whom are here today. And when I met with them in the cafeteria at the office before walking over, one of them said to me, "Thank you for testifying this. I have my own story." And that's what I hear everywhere, and I'm sure you do as well. The emotional toll of losing your job, so much of it is your identity, so much of it is your social group, and so much of it obviously is your income. The ability to be able to have health insurance and protect your family, it's all woven, and there are stories everywhere. And what we hope and are encouraged by sessions like this is that we can look at all we can do to help the individual workers and also to help businesses in the country.
Mr. Chairman? Thank you.
Let me defer to Senator Johnson.
Thank you, Mr. Chairman. I'll start by saying this is probably a lose-lose proposition for me even asking these questions, but I do think somebody has to bring the perspective of smaller employers. I mean, nobody wants to see people discriminated against. You know, we're talking about cases against Disney and against Fox News. They're big corporations. They've got plenty of money to do this. I'm talking about the little guy. I think we should acknowledge that all people who claim discrimination are not equal. There are plenty of situations in smaller businesses where somebody claims discrimination falsely. I certainly, as opposed to, and again, I don't know all the laws on arbitration, forced arbitration versus, I guess, voluntary arbitration. What I would not want to see is just a wild, wild west. Ms. Carlson, you said, we didn't see an explosion of lawsuits. But I tell you, as a small employer, you fear lawsuits. It's the only people who win generally are the lawyers, not the claimant, not the company. So I guess I'd be looking more for a middle ground in terms of, can we make arbitration work? Can we protect those who have? And again, how do you adjudicate whether it's a valid discrimination suit? So again, I'm just bringing the perspective of small employers who are just screwed by a legal system. I mean, it's awful. And again, there are plenty of people who take advantage of it. I mean, not all whistleblowers are created equal. Not all people claiming discrimination. So I'll start with you, Mr. Horton. Just can you comment on that? Can you allay some of my concerns about some of these bills that are being proposed?
Sure, thank you, Senator. That's a very legitimate concern. One of the things I was most heartened at when I looked at how the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act has been playing out in the courts over the last 3.5 years is that there actually does not seem to have been a deluge of lawsuits, and certainly not of frivolous lawsuits. Although it's not in the text of the statute, courts have imposed a common sense limitation in requiring sexual harassment claimant's claim to be plausible, which is the general standard for pleading in federal court. And I know that sounds like a low standard, but in the case of many discrimination claims, it's actually quite a high standard, where the court is inquiring whether or not these facts would actually meet the legal test and entitle the plaintiff to be.
But it starts as a lawsuit, correct? I mean, is there any middle ground first that it goes to arbitration, then get kicked up? I mean, what are the steps here?
Right. So in the case of the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, what usually happens is a plaintiff files a complaint in court, and then the employer moves to compel arbitration. And then there is some sort of court hearing in which either the court decides whether or not the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which I'm just going to call the EFAA, applies or not, and that's what happens. So in these cases, courts are evaluating, are these frivolous claims or not? And there are about 200 accessible decisions interpreting the EFAA. By my knowledge, a very small number of claims have been dismissed as frivolous. So although I completely agree that small businesses are a legitimate concern, there really is absolutely no evidence that giving workers the right to sue in court is producing a flood of claims that are unmeritorious or should not be brought in the first place.
Let me, again, I'm 70 years old, so I'm one of these guys that be concerned about being discriminated against. But again, employers also have a legitimate concern about their own liability. An older worker who's maybe losing something in terms of being able to drive. And, how do you address that within this process?
Right, absolutely. It's a delicate and important question. I think what we really need is something that we don't have because of forced arbitration, which is a sense of how these cases actually play out on the merits. I tried to research age discrimination claims in court to prepare for this hearing. It was so hard to find any because they're all sent to arbitration. So I can't tell you whether or not the age discrimination laws should be changed or modified. We just don't know.
Okay, fair enough. Thank you, Mr. Chairman.
Yeah, thank you. Thank you all for coming together here. Ms. Gressler, something you said that really stuck out to me. You were talking about the labor workforce, and I believe you said something to the effect that there are stats here that participation rates in the labor workforce of individuals aged 55 to 64 increased by 12.8%. Participation rates for those ages 65 and older increased by 8.3%. Is that increasing? Are we going to be seeing that trend growing even further as more time passes?
I think we will continue to see that increasing trend there, and a lot of that has to do with both the increased health, as we've seen improvements in healthcare, and also the reduced physical demands of a lot of the jobs that we have, and also the aging of the population. Some of it is also policy related, but there have been some studies that have shown that there is additional work capacity beyond what we've already seen. We have seen these positive improvements.
Okay, thank you. And Ms. Lamond, you had something in your opening statement that said 54% of households have no savings. I think that was of all households, but more specifically when it comes to seniors, I saw something that AARP put out from a survey last year saying that 20% of adults age 50 plus have no retirement savings, and more than half, I think it was 61%, said that they were worried that they don't have enough to be able to support them. I guess I just want to ask you if there's anything further you want to unpack on that, and also, is that getting worse as well over time?
There are additional challenges. People are trying to save in many situations, and we find that because of caregiving needs, in particular, older workers are taking a little bit more time out of the workforce. So we're concerned about that. One reason we're so focused on Social Security, obviously, is so people have that earned benefit when they retire.
Yeah, I really wanted to just put those two stats together because I think it really tells a story of what this committee and what we here in Congress need to focus in on. That we have a rising workforce in terms of an aging workforce, yes, but we also have a larger growing level of the workforce that feels significant financial insecurity. And my mom and my dad, they retired, but they are dependent upon Social Security for almost all of their income right now. And it causes so much challenge in terms of the decisions that are being made. And so that's something that I just really hope we hone in on here in this committee and in Congress to address. And Ms. Lamond, you raised it just in your last answer here about the effects that caregiving can play, when it comes to, these issues. I think we're seeing this a lot when it comes to combating age discrimination, challenges when it comes to the growing number of workers who are also caregivers need to be able to take some of their time. Also recognizing the need for businesses to be able to offer benefits and flexibilities that can help with caregiving. I guess I wanted to just ask you, if you can talk a little bit more about the intersection between caregiving and age discrimination.
Sure. Well, we know there are, based on a report we released last week, 63 million family caregivers, and 60% of those are in the workforce. So we know this is an issue not just for the caregiver, but for the employer. And we hear anecdotally from workers who are caregivers that they're a little worried about taking time out of work to say they're doing caregiving. They think that that might jeopardize their status in the company. We don't have any direct statistics on that. But on the other hand, I mentioned our employer pledge program. This is a voluntary program where employers say they are committed to leveling the playing field and work with us on things they can do. And one of the areas we hear about the most from employers right now is, how do I manage the increased number of workers I have? And not just older workers, workers of all ages who are caregivers, part-time family caregivers. How do I create a flexible workforce where they can be productive at work and also continue to be the backbone of the long-term care system in this country? I think this is a growing issue and one we'll continue to look at as we encourage more companies to hire older workers, and we encourage more older workers to stay in their jobs,
Great,
both for their financial support and for their good health and for their family.
Mr. Chairman, if you don't mind, I'd like to ask one more question, if that's okay. Ms. Carlson, we just heard Mr. Horton talking about sort of the economic implications of this, in terms of businesses, and how, at least from what we've seen so far, we haven't seen a deluge of problems that are facing businesses when it comes to some of the legislation that we passed regarding forced arbitration. You got to a little bit to this in your opening remarks, but I just wanted to offer you another opportunity to delve in a little deeper. Some of my colleagues have raised concerns about whether or not some of these actions that were taken on forced arbitration to stopping it would have negative impacts on businesses. I, for one, am very compelled by some of the responses you've given. I was proud to be able to support the efforts to work alongside you to end forced arbitration for sexual harassment and sexual assault. But I wanted to see if there's some further lessons that you learned from that to help us as we're having these discussions here on the Hill.
Thank you so much, Senator. I think everything we've discussed today with regard to the problems of Americans aging longer and needing to be in the workforce financially, the underlying message in all of that is we can improve all of those things, everything that's been discussed, but if you keep the barrier of forced arbitration, you're still going to have the biggest problem, right? We talked a lot about removing the barriers today. The biggest barrier is the idea that arbitration is being forced on these workers. All we're asking for is the choice to make it voluntary. And if forced arbitration is so wonderful, why do we use the word forced, right? We're not saying it's voluntary. The other thing I would just add is that it ain't fun to come forward. And so that's another reason why we haven't seen this deluge of cases. And to add to that, what Professor said is that it's very hard to prove these cases at the state level or the federal level. And so just offering Americans choice is what we're asking for. They may still choose arbitration, but they will know that they have the ability to use their Seventh Amendment right.
Great, thank you. Thank you, Ranking Member, for pushing forward this legislation, and thank you for giving us the opportunity to speak here.
Thank you. Mr. Horton, I liked that you said when you were trying to do your research about this hearing, it was very hard to find those cases because they are stuck behind the wall of forced arbitration. I think that is a huge impact to the legal community, to workers' rights, and just to our knowledge base as a committee. So I want to ask the panel for their examples of what you've seen with age discrimination. Sometimes it could be very subtle. Ms. Lamond has noticed, I need a high energy candidate. It's just a, cloaked word to say I don't want somebody old. In your industry, Ms. Carlson, you don't see many news anchors that are in their 50s and 60s. You see plenty in their 20s and 30s. There's a preference for youth in many industries, and particularly among women, that there's always a joke in Hollywood that as soon as you hit 40, you are no longer castable because nobody wants to see you. So I'd like to hear from each of you, what are the examples that you've heard or seen of age discrimination? What does it look like? When I travel in New York and I talk to workers, I talk to a lot of men who are engineers who say, yeah, as soon as they hit 50, they were therefore a high-cost worker, whereas they would try to hire a 25-year-old with the same degree because they could pay them half the wage, even though they were providing so much value and benefit because of their years of experience. So I really want to hear more about what does age discrimination look like, and what are the impacts ultimately, and Mr. Horton, you might have some thoughts on this, on the economy and also on the jurisprudence. Ms. Lamont, why don't we start with you?
Sure. Well, as I mentioned, what we hear the most is people are told they're overqualified. They just have too much experience for this job, even if they are saying, look, I'm interested in this, I think I can do it, I want to be there for it. We also see in the job application process some companies that recruit only on college campuses, where the likelihood of finding older workers is not as great, obviously. Some descriptions talk about no more than 5 years of experience, questions sometimes about different social media sites or podcasts in an effort to see how able somebody might be with new media. We tend to see all of those kinds of subtle comments. Digital native is very common. We hear that all the time from folks. And then in preparation for the hearing, I Googled cartoons ageist discrimination. And it was interesting. There was one that said, we really can't say anything too direct, but we can put it in really tiny print so an older job applicant can't read it. And I think, you kind of get a sense of the subtlety. Jokes about, are you going to retire? Are you going to still be able to do this? All of them comprise a picture that is discrimination.
Yeah. Mr. Horton.
Thank you, Senator. So as I was preparing for the hearing and doing research, I was reminded of the fact that one of the most egregious facts in any forced arbitration case that I've come across for a long time involved the claim of age discrimination. And I would just like to highlight it, if that's okay, because I think it really shows why forced arbitration is a barrier to justice. There was a woman who worked, she had a PhD, she was a doctor, Dr. Anderson, and I believe her employer was called Interpro. She signed an employment arbitration agreement that said that the arbitrator would decide whether or not the case should go to arbitration. And she suffered age discrimination on the job, and she sued. And so the issue facing the court was whether or not to allow the arbitrator to decide whether the arbitration should proceed. She proved that it would cost $8,000 just to decide the issue of whether to arbitrate the merits of her case. And so she introduced evidence that showed that she simply could not afford access, not to actually try her case, but to try the issue of, does she have to arbitrate her case? And that really made an impression on me because it really highlighted to me the fact that there are people with valid age discrimination claims who are being blocked by forced arbitration from pursuing them.
Ms. Carlson.
And I would just dovetail off of the professor's comments that there was a woman in the financial services industry in New York City who was telling me about her story, and arbitration is supposed to be quicker and cheaper, although the company can always outspend the actual individual, and she had spent $500,000 of her own money, and arbitration hadn't even started yet.
Wow.
So that is another barrier. It's not always true that it's cheaper and quicker. The other thing I would just say is that, of course, age discrimination is rampant in the media industry. Men get, salt and pepper hair, and they're assessed as being wiser. Women get one wrinkle, and they're out. But the problem is we're not necessarily hearing about these cases, nor are the women getting justice because they're being forced into arbitration. So I think that this, once again, would bring a fairer system to millions of Americans, and specifically today about age discrimination. I think that one other important note to make is that in my unscientific study of all the women that I've spoken to and other workers over the last 9.5 years, the vast majority, when they're forced into arbitration, never work in their chosen profession ever again. So we can spend all day long talking about the fact that people are not hiring older workers. They certainly are not hiring them if they've gone through a forced arbitration situation, because they most likely signed an NDA and then they can't explain to their future employer what happened to them at their previous job. So there's a myriad of problems here, but to me, forced arbitration is the evil.
Ms. Gensler.
Thank you. And I would just comment that I have been fortunate not to experience or to see my peers experience age discrimination, but rather the latter. And my employer currently has taken a stance to say, we really value older workers in the workforce because of what they bring, the experience and the wisdom that they can share with the younger generation has been increasingly valuable. And I would love to see more employers actually understand that and see what that brings when you can help younger workers and sharing things like conscientiousness and just establishing good work habits and helping them to build their careers.
Thank you. Mr. Chairman.
So, thank you. Ms. Gresser, can you go back to the comment you made about on Social Security, allowing people to, not be a cap and still get it? So number one is, how would that work? And number two is, how would it affect the viability of Social Security? Because we're all worried about, its viability in just a few years.
Yes, so the retirement earnings test that I described is a misunderstood part of the program. So it functions, people see it as a 50% additional tax on top of their federal taxes, their payroll taxes, their state and local taxes. So as I mentioned, this is like an 84% tax on any dollar above about $23,000 per year that an older worker earns. And this affects people who are between the ages of 62 and 67, 62 and 66. And actually, the majority of workers do claim benefits early in that window of years. And so multiple studies have shown that this significantly reduces the willingness to work when you have an 84% tax on that. People don't realize the benefits actually get added back in later on once they reach their normal retirement age, but it's perceived as a pure tax. And so it simply reduces work options. And so just by eliminating that and saying, we're not going to take away Social Security benefits, you can continue to claim early if you want to and to continue working, and your benefit will just stay the same. There won't be that adjustment later on. And this would actually improve Social Security's finances, because when people work longer, they're paying more Social Security taxes, they're paying all of the additional taxes, they're earning income that they get to keep. So across the board, this is just a common sense, good policy, I see.
Why was this set up this way in the first place?
When Social Security first started in the late 1930s, Depression-era program, they wanted older workers to get out of the workforce so that they would free up the jobs for the younger workers. So it wasn't a 50% tax then, it was 100% tax. You could not collect a Social Security check unless you stopped working entirely. And it's been modified over the years, but as it stands today, it's like this additional 50% tax.
Has there ever been a CBO score if you changed it?
I don't know of one. But I estimated an additional $18 billion in total tax revenues and an extra $8 billion in Social Security revenues per year if you were to eliminate this.
Yeah. Ms. Carlson, what else, besides the legislative solution, what else do you think employers ought to be doing to be respectful of older workers?
Well, if they want to voluntarily take away the word forced from arbitration, then we don't have to pass the law. But as I said, there's been an explosion of forced arbitration, where we now have more than 60 million Americans underneath it. In 1991, we had 2%. Right. So, I believe that passing the law is the best way to handle this, because it simply gives the worker a choice. And just taking out the word forced would make all the difference in the world.
Thank you. Ms. Horton, do you think that the Protecting Older Americans Act, does it make, if it was the law tomorrow, does it strike the right balance between the interest of the employer and the interest of the employee, and making sure that everybody's respected?
I do think so, Senator. So one of the things that I really admire about both the EFAA and the Protecting Older Americans Act is the fact that it allows employees to choose. They get to choose whether they want to arbitrate. they get to choose whether they want to litigate. I think that takes away one of the most pernicious parts of forced arbitration, which is the fact that it is essentially unilaterally imposed by employers on employees.
Thank you.
Thank you. So, older workers are the fastest growing share of the workforce. And one big reason for that is because it's gotten a whole lot harder for Americans to retire because high costs and low wages squeeze families. So here we are in the richest country in the world where I think workers ought to be able to work for fair pay and fair conditions and then retire with security. But many workers post-retirement are back in the workforce in part-time jobs. And one of the things they encounter there are what are called just-in-time scheduling practices. This is when employers give workers their schedules at the very last minute, sometimes as little as a day or two before their scheduled shift. And while that might be just in time working for an AI algorithm, looking at the latest foot traffic, for example, in a grocery store, it is great for the algorithm, but not so great for the workers. So do you go to the doctor's appointment, or do you skip the shift and not get paid? Will you be able to pay your electric bill if your shift this week gets canceled? Older workers are more likely to be part-time, where just-in-time scheduling practices are far more common. So, Ms. Lamont, you're the Chief Advocacy and Engagement Officer at AARP. Why are last-minute schedule changes particularly difficult for older workers?
Well, Senator, I think last-minute schedule changes are difficult for all workers. And I will say, I think you all know AARP has offices in every state. So I oversee a staff of 700 multi-generational workers. And my experience has been on all issues related to flexibility. It is just as much a concern of younger workers as it is older workers. I would say older workers may be juggling a few more caregiving duties and medical appointments. Mothers and fathers in their 40s and 50s are the sandwich generation, dealing with children and those responsibilities along with caregiving. And our younger staff, I find, are the busiest because many of them are in school at night and juggling lots of other duties. So I think flexibility is something that doesn't just affect older workers, but all workers. Mm-hmm. You've raised something important, though, which is when we've talked a lot about workforce flexibility, it's been framed in terms of working at home or working in the office. And really what I find most of the discussion to be about is not so much that, but work hours. Can it be flexible so maybe I can drop my kids off at school in the morning and then work a little later? Can I adjust my hours in some other ways? And I think employers that are committed to multi-generational workforces are beginning to adapt and understand how important flexibility is. I think we all benefit from knowing our schedule in advance. I was joking with the team that I think we all appreciated being invited last week to testify rather than last night. And those are the kinds of things I think we can all benefit from.
Yeah, and can you just say a word about what happens to workers when last-minute work schedule changes conflict with their obligations outside work? I've kind of given my own summary, but you're the expert. You're running a staff of 700.
Well, when schedules change, one of two things happen. You will either have to arrange something in your personal life, often with some cost, or you miss something at work. And that, depending on your employer, can be a matter for discussion or a matter for serious confrontation. Mm-hmm. And I think it really depends. And it's incumbent on all of us, I think, to talk much more about what are the labor force needs. We are going to have to engage more older workers. in jobs across this country. And what does that mean? And what does that mean also for our multi-generational workforces?
So it seems to me that we need some guidance around this. As you say, some employers are changing, but many are not. And so the question becomes, what is the right way? What should be the workplace rules? I've got a bill called Schedules That Work, and it would give employees just a couple of rights. One is the right to request a schedule that works for them without getting fired for making the request. I know that seems like common sense, but for a lot of people, that's not happening for them in the workforce. And the second thing is to say, if schedules are going to be changed at the last minute, then there needs to be some compensation for the worker. You can't hold people, in effect, on call. That is, you're going to come in next Thursday, you agree you're coming in next Thursday, you will be there next Thursday, and then on Thursday morning you get a call that says, don't come in, and don't get paid for the day. If you held your Thursday open, then there needs to be some compensation in return for that. And I think your point is right, Ms. Lamont, that it would be helpful for workers of all ages, but it is particularly helpful for workers who are part-time workers, because they face this so much more than full-time workers do, and particularly helpful for workers who have obligations outside the workforce. So I'm going to continue to work on this. I'm going to encourage other members of the Aging Committee to take a look at it, just to try to get some guidelines in place that will be helpful for all of our workers, but I think will have a special benefit for our older workers. Thank you, Mr. Chairman.
Senator Warren, let me, just as a business person, let me just tell you the issue that we're dealing with. So, because I agree with you. I mean, not, we all want to know our schedules, right? I mean, but if you think about it from the standpoint of an employer, here's what goes on. Let's say you take a restaurant. Everybody gets their reservations through Open Table. And you find that day that your reservations are down 50%, right? And so you say, well, how many people should I have come in? So you say, well, I don't need as many workers today. And so is it good for the worker? No, right? But if you tell the worker to come in, then the employer probably, it costs them money, right? So can they keep that restaurant open if they did have something? So I think in almost every industry, what my experience in the businesses I was in is everybody always joked, this would be a great job except for the customers. The customer dictates all this and how many people are going to show up that day. And in so many businesses, not all businesses, it's more stable, but there's a lot of them that the revenue that you'll get that day is completely dependent on who's going to show up. Sometimes you have a good idea, and sometimes you don't. My first business was a donut shop, and I can tell you my revenues were 100% tied to the weather. And so, but I think you got a legitimate point, because it's frustrating to somebody if they think they're going to get paid and think they're going to have not, and they save their time, and then they lose that income.
I would just say in response, because I appreciate the point you make, the question is not the customers. I get it. Customers can come or not come, and that's going to change how many workers are needed at any given time. The question is, who bears the burden of that risk? And the idea that the employer says, I want you to be available. I want you to block out your Thursday, no matter what. And don't take a class that meets on Thursday. Don't agree to take care of your grandchildren on Thursday. Pay the caregiver who's going to show up and watch your husband who can't be left alone. That the employee takes on all of that cost and risk, and the employer takes on none of it in many industries. And I think that's the part we're trying to figure out, is who is it should be responsible for that. And I think employees need a little more help on their side, and some rules that give some guidance around that.
Thank you all for coming. This was an excellent hearing. I think we learned a lot about this issue, and I really appreciate the time and expertise that you've offered to help inform the Senate panel. Thank you so much. Thank you, Mr. Chairman.
So if any senators have additional questions for the witnesses or statements to be added, the hearing record will remain open until next Wednesday at 5 p.m. Thanks.